I rise to speak in support of the Independent Broad-Based Anti-Corruption Commission Amendment Facilitating Timely Reporting Bill 2022. This bill seeks to ensure that all reports of the Independent Broad-Based Anti-Corruption Commission, IBAC, are tabled in Parliament in a timely manner. It does this while preserving relevant protections for those who IBAC may comment on in an unfavourable manner. The opposition have introduced this bill after a string of legal setbacks and roadblocks that have delayed the tabling of IBAC reports to this Parliament. These reports hold the answers about many allegations of corruption by the Andrews Labor government. Victorians deserve to have these reports tabled as quickly as possible, particularly in the lead-up to the November 2022 election. To date, we know that the Andrews Labor government is involved in at least 3 inquiries into serious corruption. These are Operation Sandon, Operation Watts and Operation Richmond. We know that Premier Andrews has been questioned behind closed doors at IBAC at least twice, but he still fails to advise Victorians whether he is under investigation or whether he is attending in a witness capacity. An ethical, transparent and accountable leader would face the people who voted him in and would let him know exactly why he's being questioned. This is not the case here. The only hope Victorians have at finally knowing the extent of this government's corruption is to wait for these reports to be tabled. And at the moment, there are just too many roadblocks and delays. It is in the public interest that all IBAC reports are tabled without unnecessary delay. Under the current legislation, Section 59N provides that on an application, the Supreme Court must determine whether an IBAC document is a subject of privilege or any secrecy requirements. The section then lists numerous things that the court must do if the documents are bound by privilege or secrecy, and the things that must happen if they are not. This bill would implement a further section into Section 59N to make it clear that Parliament's intention is that these applications be determined with as much speed as the requirements of the Act and the proper consideration of the application permit. It implements this intention into Sections 100 and 147 as well. This bill would also introduce a new section, 162AA, that allows IBAC to allow a report to be transmitted to each House of Parliament despite any pending court proceedings in relation to the report. This seeks to balance the rights of the people to initiate court proceedings with the right of the public to know what is happening at IBAC and what their elected officials are up to. It is in the interests of all Victorians that all corruption be met with strong legislative powers that have transparency and accountable government at their heart. Corruption impacts public trust in government. It erodes the trust the public have in their public sector. It has a significant adverse impact on the economy. When governments make backroom decisions that lack transparency, inequality between communities is only widened. We, the opposition, are concerned at the delays in the tabling of IBAC reports, particularly those involving the Andrews Labor government. I have previously spoken in this chamber on our motion to increase funding to IBAC and the Ombudsman. This would have provided an immediate injection of $10 million into IBAC and $2 million into the Victorian Ombudsman to ensure these bodies are equipped to complete current investigations before Victorians vote in November. In yet another attempt to evade transparency and integrity, the Andrews Labor government opposed this motion. A responsible government should stand against corruption. The Andrews Labor government has instead opted to starve IBAC of funding to slow down the multiple corruption allegations it is currently undertaking. The government is desperate to prevent Victorians from knowing the truth about these investigations ahead of the November state election. The government does not uphold principles of accountable, transparent or responsible government. They continuously spin and evade questions from the opposition and journalists. When corruption allegations are referred to IBAC, they need to be investigated in a timely manner. And when they concern our public officials, it is in the public interest that reports are tabled in Parliament as soon as practically possible. The provisions in this bill strike an appropriate balance between preserving the rights of those who IBAC may comment on unfavourably and the public interest in having these documents tabled quickly. As it stands, there are too many legal roadblocks stalling the tabling of IBAC reports, which is allowing corruption to thrive. Victorians first heard about Operation Sandon almost 3 years ago, and they still have not seen the report. The government may think it is a case of out of sight, out of mind, but Victorians deserve to see these IBAC reports before the November 2022 election. They deserve to know whether their leaders are corrupt, and they must know this before making a decision on whether to vote them in or out. These critical IBAC reports should not be denied to the Parliament or the people of Victoria any longer. I commend this bill.